Hi guys, this is Jacob Blizzard. I'm a board certified criminal law and criminal appeal specialist attorney. I practice in Texas, and today I wanted to talk to you about a topic I don't talk about a whole ton in my videos, but I want to talk to you about federal writs when you are a federal prisoner today. A lot of the topics I talk about are related to Texas writs and federal writs when you are a Texas prisoner. This is, you are a federal prisoner. That means you went to federal court originally on your case and you were convicted in a federal court and you are in a federal prison or otherwise subject to some sort of federal penalty. You're on probation or supervised release or whatever it may be. So that's called a 2255 petition in most cases. So a 2255 petition you file to get relief much in the same way that you would an 1107 petition for Texas. But I want to talk to you today about some important considerations when filing a 2255 petition. First off, that most cases, as you know, you're a federal prisoner and you've probably talked to a lot of other people who've dealt with their federal cases in their situations. Most federal cases are not about guilt innocence. They're usually about punishment. That's because if the federal government takes a case, they do not take cases that they anticipate they could lose. For the most part, the federal government takes cases that they believe they're going to win. The state, they just take kind of anything, but whatever the cops send them, they file and they just roll with it. The federal government, comes in over the state and says, oh, okay, I want this case or this case. I'm not taking this garbage case, because the evidence is bad or, the police did a bad job or whatever it may be. So the federal government, they choose their cases wisely. So it's not about guilt innocence. So what is it about? It's about sentencing. And what is sentencing about? Sentencing is about the guidelines. If you know and remember from your case, you were sentenced in accordance with guidelines, almost certainly. What the enhancements were based off your criminal history, based upon your relevant conduct, if it's a drug case, the amount of drug, guns, the amount of guns, whether things were, you were a leader, organizer, whether you were in some sort of aggravating role or committed some sort of aggravated conduct in the probation officer's view and subsequently the trial court judge's view. So oftentimes people in a 2255 petition scenario talk about the case in terms of, well, my lawyer didn't take my case to trial. He told me that I should plead guilty and that I had no chance or whatever, and he wasn't willing to fight for me. That's what a lot of 2255 petitions that are unsuccessful do. And not that they're not all unsuccessful, because some of them are, and there's really truth to a lot of those facts. But the thing you have to remember is harm analysis. Okay, harm analysis, because when you are saying my lawyer was ineffective, you have to show, one, he committed an error, and two, that it actually affected your case in some meaningful way, right? And so what the government's going to do is they're going to come back and they're going to say, well, sure, maybe this attorney, he didn't advise him of this right or whatever it may be, but he, whether he did or not, he would have been found guilty. The evidence was overwhelming. There was no doubt that this person was going to be convicted of this crime. And that saves the government in a lot of situations. Sometimes it doesn't, because there are certain rights that you have to be informed of in order to intelligently enter a plea of guilty, and so therefore it could be an involuntary plea, and that may be a good ground. But for those situations where the evidence was overwhelming and a situation where it was not a very structural based right, it's kind of one further than constitutional right. It is so important to your constitutional right that is considered a structural right. If you are not, you haven't had some structural right of yours violated, then really it's about punishment, and it's about whether your attorney filed objections to the pre-sentence report, whether those objections were well formed, whether they made all of the objections they should have, whether they sought a downward departure when they could have, based off of mitigating circumstances. whether they did some sort of mitigation presentation in your sentencing. They got letters, they got counselors, they got other people who would speak on your behalf or present some other mitigation evidence, like evidence of past abuse, past violence committed upon you, past severe poverty, whatever it may be, that influence whatever led to you into your situation. Those are important things that have to be done in a federal case, and a lot of times I see federal practitioners who don't do much of anything, and I'm sure you see it too. You get a court-appointed attorney, and they just kind of tell you, hey, you should plead guilty, man, and you're going to get whatever the guidelines say. Now, there are many good, high-quality, court-appointed federal attorneys. That's not to speak of them as a broad base, but there are groups of attorneys that don't do anything except for stand beside you while you plead guilty, and then stand beside you while the judge sentences you to whatever he wants. Well, if you got one of those lawyers, then you need to look at the pre-sentence report, do research on the guidelines and the case law interpreting those guidelines, and how those guidelines may or may not have applied to you in your case, and talk about ineffective assistance of counsel in a way that is the lawyer did not pursue objecting to the guideline sentence or the guidelines as they were applied in my case, didn't file a motion for downward departure, did not file a sentencing memorandum asking that my sentence be reduced based upon mitigating factors. So think about that when you're thinking about a 2255 petition. And that's what I've got for today. Thank you guys for watching, and we'll see you next time. Thanks.